Join me at CMC.
Get engaged and get educated.
Join me at CMC. Everyone is welcome.
Join me at CMC.
Come grow your relationships.
Join us at CMC.
CMC is real,
authentic conversation.
Engage with curious people.
Plus, we give you access to thought leaders.
Be informed, be inspired.
Through community conversation.
Come here and meet your neighbors.
Be here in the room.
ask questions,
Get answers.
Connecting people and ideas.
Learn about Columbus.
Who will you see at CMC?
Join me at CMC.
You're invited.
Watch us on live stream or in person.
You're invited.
Join the conversation.
You're invited.
Welcome to CMC!
Oh, wait, I gotta figure out where I'm supposed to be, though. Oh, okay, whatever you want me to do. Okay. Oh. Am I supposed to start now? Oh. Good afternoon, and welcome to the Columbus Metropolitan Club. Founded in 1976 by 13 visionary women leaders, CMC's mission is to connect people and ideas through community conversation. From its beginning, CMC has welcomed everyone. I'm Deb Hackathorn. I'm a principal with Civic Point Government Relations. I'm also a member of the CMC Board of Trustees. Let's begin our meeting today by meeting some of our newest CMC members. If you're here, please wave. Chad Bortle with SJB Management, Dan Sass with VACO Columbus, Judith Chess, Mariana Menke, and Brenda Penn. Hi, Brenda. Let's welcome all of them. If you're not already a CMC member, we encourage you to join. It's easy to do through our CMC website. If you're already a member, don't forget to sign up for our private behind-the-scenes tour of the brand new WOSU Public Media Studios. That is coming up tomorrow at 4 o'clock. Please also take a moment to look at the back of your form flyers. You'll see organizations that provide our not-for-profit Columbus Metropolitan Club with half of its annual revenue. Wouldn't you like to see your organization's name or logo listed there? To join these generous sponsors, please either see Jane Scott or Lainey Cuthbert with CMC. Lainey's in the back. Today's forum is supported by the Columbus Dispatch. Our live stream is presented by the Emergency Response Fund of the Columbus Foundation in partnership with the Columbus Dispatch. Please join me in thanking those folks for supporting today's forum. The U.S. Supreme Court's decision last month to reverse its landmark 1973 ruling on abortion is now dramatically restricting access to abortion services in Ohio. Our panel today is going to reflect on the court's decision and unpack its far-reaching ramifications. Please welcome today's panelists. On the far end here, Mike Gonidakis, president of Ohio Right to Life, Dan Kobil, professor at Capital University Law School, Allison Russo, Ohio House of Representatives Minority Leader from District 24. And our host, Jessie Balmert, reporter with USA Today's Network Ohio Bureau. You can learn more about today's speakers in your form flyer. To set the stage for the conversation today, Dan Kobil is going to provide us with a brief overview of the history of the Supreme Court's recent decision. Professor Kobil, the podium is yours.
Thank you, Deb, and thank you to the CMC for asking me to join you. I was told I have 5 to 7 minutes to discuss almost 100 years of Supreme Court history, so I'll either talk really fast or succinctly, probably a little of both. The area of law that this concerns is the Due Process Clause of the 14th Amendment to the United States Constitution, which states that no state can deprive a person of liberty without due process of law. So the question over the years has been, what is the liberty that is protected by that? Very early on in 1927, the court heard an appeal by a woman from Virginia who was scheduled to be involuntarily sterilized by the state of Virginia in a case called Buck versus Bell. In your materials, I have a small version of the slides that I often use to teach this with a picture of Carrie Buck. She argued that that was a liberty, the liberty to procreate was one that the Due Process Clause protected. And Justice Holmes, in an infamous opinion, said no, it was not. That did not have a lot of reasoning, more rhetoric than reasoning, but rejected it. And in fact, Virginia continued to do involuntary sterilizations well into the 70s as a result of Buck versus Bell. The court started to change its approach, though, to this question of reproductive freedom in a case called Skinner versus Oklahoma, where the court considered whether it was permissible to sterilize 3-time criminals. And perhaps some here will not be surprised that this involved a claim of a man, and the court said you can't sterilize a male criminal in this case because this would be forever depriving him of a basic liberty. The court, again, did not give a lot of analytical structure to it. That came for the first time in 1965 in a case called Griswold versus Connecticut, often viewed as the beginning of a recognition of a right of privacy under the Due Process Clause. Griswold considered whether a married couple could be denied access to contraceptives. And in a landmark opinion that that essentially sparked a great deal of disagreement on the court. Justice Douglas held that although there was uncertainty about where the right came from, that the Constitution prevented the government from interfering with such a fundamental decision about whether to bear children, at least for a married couple. This was then extended to single couples in 1972 in a case called Eisenstadt versus Baird, which was interestingly decided while Roe versus Wade was pending. Justice Harry Blackmun took 2 years to write Roe versus Wade. He was debating about it. Eisenstadt came out, and ultimately in 1973, Roe versus Wade was decided under the Due Process Clause of the 14th Amendment, and Justice Blackmun reasoned that the history in the United States was to permit women to terminate pregnancies at least prior to quickening, the moment when they could feel a child moving inside them. And therefore, he held that the liberty was at least to terminate pregnancies for some period of time during a pregnancy. And he said that the court would strictly scrutinize. That's a term I know my former students here will remember. Strict scrutiny means that the court looks very closely at the rationale and the means being used by the government to achieve its goal. And if you look at my fourth slide, this shows how the court essentially conceptualized strict scrutiny. Strict scrutiny said that the government basically does not have a compelling interest in terminating the right to end a pregnancy until a fetus is viable. The court said that viability was that's the moment when a fetus is capable of meaningful existence outside the womb. At that point, the government could prevent an abortion from occurring unless it was necessary to preserve the life or health of a woman. The court maintained that strict scrutiny position until 1992. In 1992, we again thought that Roe versus Wade was going to be overturned. I remember I had invitations from all 3 Columbus news channels to speak the day that Casey came out because it was expected that Roe would be overruled. In fact, a trio of centrist Republican justices watered down Roe slightly, but maintained that rule that the government cannot prevent termination of a pregnancy until the point of viability. Casey remained the law until the Dobbs case was decided, which essentially adopted the dissenters' positions that we had had in Roe and in Casey. And Dobbs held that both Roe and Casey were wrongly decided, that in fact there is no fundamental liberty for any termination of pregnancy for a woman. The Constitution, according to the majority, does not mention abortion, hardly surprising given that there were no women who were allowed to be part of the framing, and in fact were not allowed to vote at the time of either the framing of the original Constitution or the 14th Amendment. The court also said that the history and tradition in American law did not support a right to terminate pregnancy, and because there is no fundamental right to end pregnancy, states can regulate in any way that is not irrational, and that any law states pass regulating the decision to terminate a pregnancy has a strong presumption of validity. The court did not mention any exception for life or health of a woman, nor did it mention that the Constitution requires any exception for rape or incest. Finally, I would just like to very quickly say that in essence, what this has done is thrown open a great deal of uncertainty. What the strict scrutiny approach of Roe and the approach of Casey had done was essentially prevented legislatures from passing very many laws in this area. Now we are going to see legislative battles in 51 jurisdictions, a lot of litigation over whether there's any constitutional requirement of an exception, whether a state could choose to require a woman to die, as Ireland did at the time when they banned abortions, whether you'd have to risk sterility, deliver a rapist child, those sorts of things. A lot of litigation on whether the state constitution actually protects a right in an individual state. Can states punish citizens who obtain abortions lawfully in other states, limit the right to travel, limit commerce in the morning after pill, allow bounties against women or those who assist women in obtaining abortions? And finally, our other privacy rights like contraception, the right to gay marriage, the right to homosexual sexual activity, all of which had been protected under the Due Process Clause. Are those all potentially fair game now for legislation as well? And that is 100 years in about 7 minutes. Thank you.
Thank you, Professor. I'm not that succinct in my writing, so I'll give you commends today. Hi, my name is Jessie Balmert. I work for the USA Today network of Ohio papers. That includes the Columbus Dispatch, but also the Cincinnati Enquirer, all the way up to the Akron Beacon Journal. So I'm going to give a quick overview of where the law stands in Ohio today, and then I'm going to get to our panelists who are quite esteemed and are going to tell us what's happening next. So I think abortion is a medical decision, it's a personal decision, but also across the nation, it's a political decision. It is something that's been debated in state houses across the nation and has been debated in Ohio for decades now. Ohio's GOP-controlled legislature has repeatedly passed laws to ban abortion after a set number of weeks, certain procedures, adding hurdles to clinics in recent years. Democrats protest this, but don't have the votes to really stop them. Until recently, many of these laws were blocked in federal court under the protections of Roe v. Wade and Casey, as the professor just mentioned. But with the Dobbs versus Jackson's Women's Health Organization decision, these laws are taking effect. Most notably, the Ohio has a ban after fetal cardiac activity is detected, which is about 6 weeks into a pregnancy before many people might realize that they are pregnant. And that is the law in Ohio right now. I guess my initial question for our panelists, and I'll go to Leader Russo first, was what was your initial reaction to the Dobbs decision? We're about a month out. What was your initial response?
Well, thank you, Jessie, for moderating, and thank you all for being here today for this important conversation. I would say, my initial reaction was not surprised, but I think the finality of the decision, of course, we got a preview of this, and the leaked decision was still a gut punch, I think, to most of us, and, the reality hitting of what this meant. Anger, frustration. I think all of us who had been paying attention to what was happening in the courts and what had been happening in the state legislatures, particularly here in Ohio, we knew that the repercussions of this would be very immediate and it would be very swift and very problematic. And we've absolutely seen that play out over the last couple of weeks as not only the case of the 10-year-old from 2 weeks ago, that was horrifying, and, having to travel across state lines or be forced to give birth here in the state of Ohio, but also what we're hearing from physicians and providers in normal obstetrical and high-risk obstetrical care and the implications, none of which, by the way, was surprising to those of us who sat through the debate of these bills, and I was one of those legislators, because this is exactly what doctors and advocates for survivors of sexual abuse told us would happen. So it wasn't a surprise, but still, I think lots of anger and frustration, and I certainly am feeling that out in the community.
Mr. Gonidakis?
Thank you, Jessie and Professor. Great. I felt as if I was in my constitutional law class again there for a moment.
Sorry for that.
No, great job. Great job. Jessie, to answer your question specifically, we were elated. I've been with Ohio Right to Life for 14 years. but there's been men and women in the movement, the pro-life movement that is, for the past 50 years working for this day and passionately advocating in a peaceful manner that is for this day. And make no mistake, as I've said to you and your colleague Daryl Rowland many, many times, overturning Roe v. Wade does not make abortion illegal. It's not illegal in Ohio right now. Right now in the state of Ohio, abortion is still legal. It's legal in vast majority of states. In New York and California, abortion is legal up to and through the 9th month of pregnancy in those two states, based on the legislature and the governors that were duly elected in those states. Overturning Roe allows each state to set their own policy. The men and women in this room can go to the state house as I do 5 days a week and advocate for what I believe in. I strongly encourage you to do the same thing. Overturning Roe just brings it back to each individual state to set their policy, and we're elated for that because we believe the culture here in the Great Buckeye State is a pro-life culture, and we're going to continue to advocate for those things that help protect and save innocent lives.
Thank you. There's been a lot of focus on exceptions to these abortion bans, and one is an exception for rape or incest. Ohio's current law, which bans abortion in about 6 weeks, does not have this exception, but the Pew Research Center says that about 69% of people would support an exception for a pregnancy that results from rape. I guess, why does Ohio not have such an exemption?
I will start with that first. So as noted, certainly the 6-week abortion ban that is currently in place, which effectively does ban abortion for most women because that is before most people discover that they are in fact pregnant. There was a lot of debate and questions in committee about why there were no exceptions, but let me be clear. Abortion is the normal part of appropriate and sometimes necessary healthcare for women. So while these exceptions, we're going to spend some time debating them, let's be super clear about abortion is part of normal healthcare. These exceptions, I think represent, again, or lack of exceptions, it represent a very extreme view of this issue. I can appreciate that people have very nuanced views of this issue, but no exceptions is so far out of sync with where the vast majority, not only of Ohioans are, but Americans are on this issue, that I think it reflects the extremism that we see in Ohio's legislature. And Mr. Gonidakis talks about going to the legislature to advocate. The majority of Ohioans support a right to abortion care. However, we have highly gerrymandered districts that create representation at the State House that doesn't allow a reflection of where the majority of Ohioans are. And unfortunately, that is going to be maintained. No accident that Mr. Gonidakis was the lead plaintiff in the federal lawsuit that usurped our ability to have fair districts to fix this. So that's an empty claim to say that you can just go and advocate because that's not going to happen because of our legislative districts, the gerrymandering, and what we see as a result of that, which is extremism.
Yeah, I filed that lawsuit. Not the topic for which we're talking today, but I filed that lawsuit because I was protecting not just my constitutional rights, but everyone in this room, whether they vote Democrat or Republican, for their right to have a vote. And that's what happened. So like it or not, hey folks, there's a primary on August 2nd, and I strongly encourage you to go out and vote. And there's an election in November, and you have two choices for governor, one that's devoutly pro-life and one that's devoutly pro-choice. Go vote, go vote. And may the best person win, right? And if your person wins, I'm sure the laws and policies will be in your favor. Back to the issue for why we're here today. First and foremost, it's not true that there's a 6-week ban in Ohio. If you read the Ohio Revised Code, nowhere will you see in the Ohio Revised Code does it say there's a 6-week ban. The standard in Ohio is that cardiac activity. We all develop different. It could be 7 weeks, could be 8 weeks. In the Columbus Dispatch today, they said in the Columbus Dispatch today, I actually read it, and you should too, that over 75, 80% of the women who had an abortion pre-6 weeks knew they were pregnant. So when Leader Russo says that they don't even know, well, someone's not right, then either the Columbus Dispatch is wrong or Representative Russo is wrong on this. So I'm here, we can talk about facts. If we want to talk about opinions, that's fine too. But the fact of the matter is that we're talking about an innocent human life here. And we're going to do as a society, which I hope we would all agree that we should do, whether you're black or white, whether you're gay or straight, rich or poor, whatever you are, you should have the intrinsic right to life and fulfill your God-given purpose. That's what we believe.
I'm going to touch on a case that's been in the news a lot recently, and Leader Russo touched on it a bit, but 10-year-old girl obtained an abortion in Indiana because Ohio law no longer allows the procedure after fetal cardiac activity about 6 weeks. Gerson Fuentes was recently charged in Franklin County accused of raping that girl. These are horrific circumstances, I think we can all agree, and thankfully pretty rare. But should Ohio law permit that girl to have an abortion here? And I'll start with you, Mike.
Can you rephrase the question?
Yeah, should Ohio law permit that girl to have an abortion here?
We're talking about the 10-year-old rape victim.
Correct.
Yeah. In our opinion, she was not forced to go to Indiana. She could have had that abortion here. According to the facts for which we know from the police report, her mother told whether it be Franklin County Children's Services or the county prosecutor or law enforcement on June 22nd. The Dobbs decision wasn't decided until June 24th, 2 days after they went to the police. So whether it be pre-Dobbs or post-Dobbs, she still could have had the abortion here in Ohio because we have the exceptions to save the woman's life or to prevent any substantial or irreversible health effects. She could have had that 10-year-old could have had that abortion in Ohio. I don't know why she had to go to Indiana. She didn't have to. She could have had that abortion legally at an abortion clinic here in Columbus, Ohio.
Leader, would you like to respond to that?
Yeah, so absolutely. I think that this young child should have the right to have abortion here in this state, as should every other woman who chooses that abortion is appropriate for them. But, conveniently, what is left out of this is that Ohio also has a 24-hour waiting period. So the hurdles that women, young girls have to jump through even to get abortion care before the Dobbs decision is quite tremendous. In addition, I will say many of the physicians that I talk to in light of the Dobbs decision, as well as law that is now current in the state of Ohio, there's a lot of ambiguity in this law. It is not clearly defined, what is the life and well-being of the pregnant woman? That's not clearly defined. It turns out if you are a physician and you're facing not only losing your license and coming before the state medical board, again, which Mr. Gonidakis sits on, or you're facing a fine, or you're facing a 5th-degree felony charge, you're pretty risk adverse to moving forward with a procedure, not knowing what the clear answers are. You get attorneys involved in that, and it becomes even more risk adverse. So it's not surprising to me at all that the decision was made to travel across state lines and not take that risk here in the state of Ohio. It's also not clear that this child or the physician treating her would have been granted an exception. And that therein lies the problem with the law as it currently exists. One of the many problems is that it is very ambiguous in this state, and physicians right now are making decisions or being forced to make decisions about whether or not they risk their practice, their licensure, and it is delaying necessary and appropriate care for pregnant individuals throughout this state.
Professor, you talked a little bit about exceptions and how this was going to be litigated. Could you, weigh in or provide some insight on that?
Exceptions for rape or incest?
Yeah, or for the life
or
of
the life or
pregnant
health.
person.
Essentially, that will have to be litigated in states where they deny those. So what will happen now is that in a state like Ohio, which denies an exception for rape or incest, there will essentially be another constitutional lawsuit under the Due Process Clause, which will say there is a liberty to terminate a pregnancy that results from rape or incest. And essentially, the lower courts will likely follow the approach that the Supreme Court followed in Dobbs, which is to say, historically, could women who were raped or conceived through incest allowed to terminate a pregnancy? So that is essentially what the Dobbs majority said would be necessary. So I would tell folks like my former students or Mike, if you want to litigate constitutional issues, you should also go and get a PhD in history, because now that is the main ground on which we decide these things. and advocates for women's rights are obviously going to be at a tremendous disadvantage because of this was a framing that did not include women or enslaved people or many who were in the country but not deemed persons by the framers.
Thank you. I think there's a lot of question about what's going to happen going forward, what Ohio's law will look like going forward. And I know the Senate Republicans are working on a bill to ban nearly all abortions without exceptions for rape or incest, but some exceptions for potentially the life of the pregnant person or woman. But we do have a bill that has been introduced, so I might talk a little bit about House Bill 704, which would ban abortions at conception before implantation. There's concerns that this could affect contraception or effectively ban in vitro fertilization. Should Ohio pass such a law, are advocates, opponents of abortion access going after in vitro and contraception as well? Whoever wants to start.
Sure. I think we should have the debate. That's what the Supreme Court said each state should do, whether it be Ohio or the 49 other states. They're on break right now, as you know, Jessie, better than anyone, and they're probably not coming back till, or actually Leader Russo can tell us when you're coming back, probably after the election during lame duck, and we'll have that debate there, and the state house is open for everyone to come in and voice their opinion. As you said, the legislation is being drafted, but from what I've been told, it will be a ban on abortion. If it gets through the House and the Senate into the governor's desk during lame duck, it's crazy times during lame duck. We'll see, but let's have the debate. Let's see where we are. Let's look at all these issues that a lot of these issues are a matter of first impression. Look, for the past 50 years, we've been saying, well, someday maybe if we ever have a court, but here we are today. So to sit here, any of us to sit here and say, this is exactly what we should do or not do, I think it's a little short-sighted. That's why we need to sit down with all the right people in the room and come up with the best policy for the state of Ohio.
So what we will see next is more extremism attacking reproductive freedoms here in the state of Ohio. I absolutely believe we will see an absolute abortion ban, likely without exceptions. I would not be surprised if we see a push towards this personhood legislation, which would impact absolutely contraceptive care, many forms of contraception, would impact some families' options for IVF treatment. And again, this reflects a legislature that is completely out of step with where the majority of Ohioans are on this issue. Even if you've got nuanced feelings about this, a very small minority of Ohioans want a complete abortion ban. What I hope comes next, and what members of my caucus are working towards, as well as many other advocates, is turning this issue back to the voters of Ohio and enshrining these protections in our Constitution through a ballot initiative. I think we will see efforts towards that in the next year, certainly not in November, but after that. And we'll continue to have debate because, again, when we poll Ohioans, while their feelings are nuanced, the majority support the protections that were in place by Roe. And it is important that we reestablish that and that we reaffirm that in our own state constitution.
Jessie, let me be clear, very clear here. I know no one, including myself, that opposes contraception, that opposes birth control, that opposes IVF, that opposes any of that. I know nobody. Nobody at the State House, nobody at Ohio Right to Life opposes any of that. Let's be clear, none of that's coming in any future legislation or legislator. It's true, hold me to it. I'll oppose it if someone introduces it. I'll testify in opposition. Hold on, I'm going to finish my point, and then you can have yours.
Actually say this.
Okay, where's the legislation then, Allison? Show us where the legislation
personhood
is.
legislation, and
the personhood bill is one sentence. There's nothing in it, and so it doesn't say that. That's not a true statement. Okay. Secondly, we will see what happens with the voters in an election here, but then also more importantly during our lame duck session, what we come up with as a community, as a state together, and what it is going to be, and then the voters can decide if they support it or not.
I will respond to that. There absolutely has been a legislator in the Ohio House who has indicated that they would consider bans potentially on some forms of contraception. And let me just say this idea that we're going to have a community decision about what legislation is made. I've sat on health committee, a committee that gets the majority of these abortion ban bills coming through. There is absolutely no community discussion. We hear from hundreds of physicians and patients and advocates talking about what the unintended consequences are of the legislation that Ohio now has in place. And there's no consideration of that. These bills pass anyway, even when there is overwhelming opposition to them. And again, that is reflective of politicians who sit in the state house who are unaccountable to voters because they are in districts that allow them to run safely and cater to a very extreme wing of their party.
I am going to move it on, but I think it is important to watch for what legislation is introduced later this year and, give it a read for yourself, read what our analysis, I'm sure myself and other state house reporters will be covering what is actually in this bill. Moving a little bit along, segueing into the constitutional amendment, for Leader Russo, Republicans argue that Democrats support abortion up to the point of delivery. You see that in campaign talk and just like statements from party leaders. So is that the case? Where would you draw the line?
Well, first, let's be clear that this is a red herring for, throwing out, I think, extremism that frankly doesn't, if it happens, it is extremely rare. And let's be really clear about when you have late-term abortions, who we're talking about here. These are wanted pregnancies. These are parents who are facing devastating diagnosis. This is absolutely the most horrible, in many cases, the most devastating thing that has ever happened to many of these individuals who are having to make these excruciating decisions. These are absolutely wanted pregnancies. And to throw this out stigmatizes those parents who have to make these horrible decisions. And by the way, we've heard testimony from individuals at the State House who have faced this. I cannot imagine, but I want to be super clear. It is a red herring. And to me, it is completely insulting to the very small number of parents who are faced with this horrible decision when it arises.
Yeah. If you're crafting like a constitutional amendment, though, what would something like that say?
So I want to ensure that the protections that were enshrined or that were in place due to the Roe decision are enshrined in the Constitution. And that is, again, what is viability? Where is viability? The science has changed for that. And so what I will say is that's what the constitutional amendment is about. The states have always been allowed to make decisions about what happens after viability. But let me be clear that this is a red herring. What I'm more concerned about are the instances where we are forcing childbirth on young girls, young women. We are delaying appropriate and necessary obstetrical care to individuals, which we know that is a reality. That is happening right now here in the state and across the country because of this decision and because of the barbaric laws that we have in place right now here in Ohio.
I wanted to move on a little bit to the root causes of unplanned pregnancy. U.S. Centers of Disease Control and Prevention recommend strategies for reducing unplanned pregnancy, things like insurance coverage for contraception or comprehensive sex education. I guess, why is Ohio not addressing some of the root causes that might lead someone to an abortion? Either of you?
I'm happy to take it.
Well, I'm not sure they're not. I mean, sex education is taught in our schools, in our public schools, it is. I mean, to throw out saying that why aren't we doing that in Ohio? Well, who says we're not? I mean, contraception is available in pretty much anywhere in the state of Ohio. You can go to CVS, Walmart, Giant Eagle, and you have access to contraception. It's given away free at Ohio State. So to say that there's barriers to entry to contraception in Ohio, that's not true. It's readily available at pretty much any grocery store in the state of Ohio, and free for most parts through health insurance plans in the private sector or in taxpayer-funded insurance plans. So I'm not sure that there is that problem like that exists in Ohio. If it's another state, well, I don't know. Maybe in another state it is, but it's not here in Ohio.
Yeah, I guess to clarify, Ohio doesn't have statewide health standards, for example.
So I'll take a stab at this. That's absolutely correct. We are the only state in the country that does not have standards for health education in our state and in our schools. So the sex education that some young people and our youth are getting varies substantially depending on the school district that they're in. And the individuals who are providing that education, which may be, in many cases, is forced to be abstinence-only education, which we know is the least effective form of sex education in terms of outcomes, measurable outcomes. In terms of contraceptive services, I think that this is a space where I hope that we can find some agreement with my colleagues across the aisle, because the most impactful form of reducing the number, or impactful approach that you can take to reducing the number of abortions that happen is actually through providing free and easy access to contraception. And we know that after the Affordable Care Act was passed, which required the coverage of contraceptive care, we had a dramatic reduction in the number of abortions that happened across the country because women and individuals could plan better and have access to that. And there are certainly things that we could do here. Part of it is having access to insurance coverage, but another part of it is reducing those barriers to getting a prescription, or even is a prescription required. Many states have, for example, passed legislation that you can go directly to the pharmacy and get contraception, which I support. So I think that those are things that we should absolutely be considering and proactively doing. We should have been doing them a long time ago before this decision, but we have a lot of work still to do.
I might direct this question to the professor. Justice Clarence Thomas, in his opinion, wrote, "We should reconsider all of this court's substantive due process precedents, mentioning rulings protecting same-sex intimacy and gay marriage. Should LGBTQ Ohioans be worried about this decision? I guess, what are the legal ramifications of this particular opinion?"
Maybe it's because I'm a lawyer, but yes, I would say be worried. I always anticipate the next shoe to drop, and Justice Clarence Thomas, although he was alone in that opinion, has actually taken a great deal of credit for control of where the court has gone today. So in the majority opinion, it said, we are not going to reconsider contraception or interracial marriage, all things that had been decided under the Liberty Clause. But Justice Thomas quite correctly points out that the gay marriage case, the Lawrence decision, which allowed homosexuals not to be jailed for engaging in sexual activity, and that those cases were all decided against a backdrop that rejected history of punishing this conduct. So what his opinion says is, the logic of our opinion says we must revisit all of this law. The majority said, no, we're not going to do that. Just we're only getting this one right. So don't worry about that. And Justice Kavanaugh has a concurring opinion that says that. But I would essentially say that if the makeup of the court changes again, that would not be out of the question. And Justice Alito, who authored the majority opinion, specifically did not mention gay marriage in his list of cases that we're not reconsidering. And he has spoken very passionately about how we must correct that. So I would not be very confident if I were concerned about that right.
I have one more question for our panelists, but then we're going to move to questions from our live stream and in-person audiences in just a few minutes. If you have a question, please make your way to the microphone. If you're watching online, you can type your questions into the chat. But I am going to ask one more. Even when I started covering this topic about 7 years ago, a politician's political party didn't necessarily define their position on abortion. There were Democrats who would vote for abortion restrictions. There were Republicans, even now, who will vote against some of these restrictions. Why do you think this has become so divided? And, why do you think that has changed in recent years?
I would submit there's a lot of pro-life Democrats. In my past 14 years, I've been in all 88 counties multiple times. You go up to the great county of Cuyahoga, relatively blue county, largest suburb in Cuyahoga County is Parma. The mayor of Parma, Tim DeGeeter, my friend, pro-life Democrat. His predecessor, Dean DePiro, both of them former state reps, Democrat, pro-life, devoutly wear it on their sleeve and proud of it. There's tons of pro-life Democrats in Ohio. And we work with them closely all throughout the state, get them to vote for pro-life candidates. As it relates to why the Republican Party is electing pro-life and the Democrat Party pro-choice, primaries. Look, you can't win a Democrat primary statewide if you're pro-life. You can't win a Republican primary statewide if you're pro-choice. It's the same. It's not different from the Republicans and Democrats. If Allison was pro-life and that she had a pro-choice primary opponent, she would lose.
Leader.
Well, let me be clear. I am very pro-life. I'm pro-life for the life of the mother, the life of the young girl who wants to have a future, life of having very healthy babies as well. Listen, I think that abortion is not and should not be a political issue. I hear from people all across the political spectrum who have varying opinions on, again, nuanced opinions on this issue, but I absolutely don't think that this is a political issue. I think this is a basic question of, do you believe in the fundamental freedom of individuals to determine when and how they start families and how, what they do with their bodies. And that is a fundamental freedom, a fundamental right that I think individuals across the political spectrum hold. Certainly it's what I hear from my constituents. And, again, I think that's why so many people are so disturbed and outraged by what we see happening right now in the state of Ohio and in our legislature with these extreme laws and continued pushes towards outright bans and near bans at this point on abortion care.
So I guess I'd encourage, Lainey is going to curate some of our questions from the live stream, or if you have a question inside the room, to go to our microphone right now.
Live stream.
Okay.
So what I will try and do is I will ask a question on their behalf, and then we'll go back and forth between folks in the room. So please do get up and ask your questions. Kara Jacobs from the Cincinnati Physicians for Change states, maternal mortality rates are unacceptably high in the U.S. compared to other developed countries and continue to rise. Studies have shown that states with abortion bans have higher rates of maternal mortality, and the risks of death associated with childbirth is approximately 14 times higher than that with abortion. Given those facts, what has Ohio Right to Life done to improve maternal mortality rates in our state?
Okay, good question. I'm not sure what state has a total abortion ban until 3 weeks ago. So those stats, I'm not sure that they can be verified. But to answer the question, what are we doing at Ohio Right to? Let me tell you what we're doing. We advocate on a budget every 2 years. We have state budget, as Allison knows, and we advocate for hundreds of millions of dollars to go to women, whether they find themselves in an unintended pregnancy or not, and the money does go there. We have over 125 pregnancy centers in Ohio where a woman can get for free diapers, formula, parenting classes, prenatal care, ultrasound services. Some of them are medical as well. Catholic social services, our federally qualified health centers like Lower Lights Ministry in the Franklinton area does amazing work. We make sure they're funded every 2 years in the budget. Our great governor, Mike DeWine, on June 24th, issued a website, announced a website where there's over $1 billion available currently just from the state dollars. This doesn't include local or county dollars in all 88 counties that are there to help women, their children, and women that find themselves in unintended pregnancy. The services are there right now, and we're proud for the work we do to help support women.
Hi, I'm Jeff Lemachek. So my question is a little bit added on to what was just asked. It made me think, if these women are going to have the baby, if they're emotionally or financially not able to take care of that child or children, I mean, we're looking at thousands, millions of babies. Who's going to take care of them? Will pro-life step up to the plate and take care of these kids to their adulthood? Because if you're not going to step up the plate and do that, then you might want to consider changing your name from pro-life to just pro-birth at that point.
Yeah, I've heard that before. Here's what I tell you. I personally worked on the adoption issues. Ohio's adoption laws were archaic for a long time, and about 5-6 years ago, both of my children are adopted. My son is from East Cleveland. Brought him home when he was 3 days old, and we brought our daughter home from Guatemala when she was 7 months old. And we're very blessed, but Ohio's adoption laws were terrible. And we worked hard to ensure that you didn't have to take out an equity line on your home to afford to pay for an adoption. We have great programs here in Ohio now. We reduce the red tape, and adoption is a great option, whether the child be a newborn baby or in our foster care system. Look, there's 11.9 million people that live in Ohio. 20,000 abortions in Ohio last year, 20,000 too much, according to me, and the people for which share my opinion. But, you know, you say millions, we're not talking about millions, but those women that find themselves in unintended pregnancy, we want them to have their child and raise their child. We want to make sure that the social service safety net is there. And if there's gaps in the social service safety net, I can only hope and pray Allison Russo, her party, and the Republican Party, I'm not an elected official, she is, they can sit down and fill those gaps wherever they are, because that's not a partisan issue, that's a human issue. Let's make sure that if there's any gaps in the services that we offer, whether it be in Franklin County, Mercer County, or Meigs County, and the state of Ohio is there to help all people, black, white, rich or poor, gay or straight.
So I would like to respond to this as well. So first of all, I'm hugely supportive of reforms to our adoption process in the state of Ohio and making it easier for adoption. This is not an either or choice in my mind between reproductive freedoms and supporting that and supporting the adoption process. That said, there are more than 15,000 children right now in the state of Ohio in our foster care system. Our foster care system has some of the worst outcomes in the country. And we know that 1 in 5 children in the state lives in deep poverty. So I say all of this to say that Ohio is not a great place for children at the moment. And certainly my caucus has been advocating for a lot of these social services reforms. In fact, in the budget process, again, I sat on the subcommittee listening to much of the testimony related to this space. You know, our foster care system was short $50 million in funding in order to get it to a place where we could perhaps start to improve outcomes, get more children placed in homes and with family rather than placing them in institutions where we know they have much worse outcomes. I say all of that because unfortunately, when we've been advocating for paid family leave, for affordable childcare, for reforms to the foster care system and funding for the foster care system, I co-chaired the Children's Caucus, which is a bipartisan caucus. Ohio Right to Life was not at the table. The anti-abortion activists are not at the table when we have for decades been advocating for this. And to step up now after the fact, is interesting. But, I do hope that they come to the table and they as strongly advocate for these issues as they have for abortion bans.
We've been there for 50 years, Allison. Our pregnancy center's been in existence for 20 or 30 years. You can't walk into a Planned Parenthood and ask for diapers, formula, car seats, cribs, or clothing, but you can walk into a pro-life pregnancy center and get all that for free today.
Fake
And that's a
crisis
fact.
pregnancy,
It was a
Cindy,
fact
that
10 years
also
ago, and it's a fact
encourages
20
women
years
who
ago.
are stuck in situations of domestic abuse to stay with their partners so that they can
No.
carry the pregnancy.
Come visit one of our centers.
I have, thank
Come
you.
visit. Come visit them.
We'll take the next question.
Marla Jones asks, why don't we stop payments and coverage for Viagra and similar prescriptions if we are considering stopping coverage for birth control? Shouldn't we be consistent regarding the coverage and reimbursements and access for both of these?
I would say that yes, we absolutely should be consistent. And again, to me, I support the right to reproductive freedom. And that means that I also support the right of men to access whatever they need to have control over their reproductive freedom as well. So to me, this is not about banning access to medications. This is, again, about putting these decisions back with individuals and with their healthcare providers, not me as a legislator. I have no say in that as far as I'm concerned.
We'll take the next question.
My question is for Mike Gonidakis. So I do want to give like a little bit of background. I actually was sexually assaulted, ended up pregnant. During college, I graduated from a Catholic high school. I don't recall if we had sex education, and I didn't have it at home. So I felt that after that rape, there was no way I would be pregnant because I didn't want it. So finding out I was pregnant was difficult. Even admitting that it happened was difficult. So I guess my question is, I also have a 10-year-old right now, and she suffers from precocious puberty, so she's already started her cycle. And just knowing that there's a chance that something could happen at any point, and we don't have a choice at that point what to do. I mean, I'm not going to put her on birth control right now. I also have issues with birth control. I get blood clots. I have migraines. And then I also have extreme allergies as well. So there's a limited amount of resources for us. And also we have irregular periods. So I know most people think that it's going to happen at a certain point every month, but if you don't find out and you don't know for a while, you could be past that 6 weeks even before you even know that you're pregnant. And I know that we're saying 6 weeks, but it could be 5 when you see that heartbeat. So my question is, how do we feel comfortable? How can we as women feel comfortable going forward? And if we do have these exceptions that are given, do you feel that it's okay to force us to tell our stories to be able to have access to healthcare?
Well, first of all, I'm not sure what the question is specifically for me. I pray for you and your daughter, and I can tell you that.
I'll clarify my question.
Okay.
So for pro-life, you're saying that you're pro-life.
Yes.
So if there are exceptions here in Ohio, I know that if there are going to be exceptions, do you feel that we have to then tell you what happened to us for us to be able to get the proper health care?
No, you don't have to tell me. You don't have to tell Ohio Right to Life. You have to talk to your physician. That's what Ohio law says. You have to tell your physician. And you should tell your physician.
But that's my point. So why can't we just make that decision for ourselves and decide when we want to move forward and be able to heal?
Well, again, you don't have to tell me, Allison, the professor.
Well, we have
anything.
to tell someone,
Okay.
right?
Yeah,
To
your
be able to
physician,
have-
your doctor. You should tell your doctor. You should disclose
But what
everything
if
to your doctor.
what if you just want to be able to have access to abortion without having that story be told?
Yeah. Well, your story doesn't have to be told to anyone other than to your doctor.
Yeah. Okay. Well, so I was just wondering if when you have exceptions that way, that's kind of, you're forcing people, a woman, to go through that, relive that trauma again, when maybe they're not prepared to have that conversation or to even accept that that has occurred.
Again, at the end of the day, we want to make sure you have the best health care that everyone else in this room has access to for you and your daughter. And if you're not getting it, then there's a problem. There's a gap in our social service safety net. We supported Medicaid expansion, Ohio Right to Life. I personally testified in support of it when it wasn't popular to do. We have it today. So I don't know what your income levels are or what your situation is, but you have access to the doctors that people in Upper Arlington have access to, New Albany and Dublin too, and I don't know where you live. So at the end of the day, we have the best health care in Ohio for you and your daughter, and you should access it.
Yeah, I think my decision was definitely, I realize living in Dublin, my decision might be different than someone who lives in a different area. I do have 4 kids of my own, and I'm a 2-time surrogate. So I did make those decisions on my own to be able to get pregnant when I wanted. But I guess my question, and I think you've answered it, is it was just, if I did not choose this, why then do we feel comfortable making women tell their story to be able to have an exception to get the proper health care? If they make that decision for themselves, that should be a private decision. And it's between them and really and their God.
I'm sorry. It is a private decision between you and your physician. So again, I know of nowhere in the Ohio Revised Code that requires you to publicly talk about that decision.
Yeah, you do have to make the decision when you're filling out the forms. It does ask the question if you've been sexually assaulted for you to be able to be even covered by insurance or to be treated at that time as a rape victim.
Okay.
Thank you.
I guess I'll. Lainey, do you want to take one more question or do you want to wrap up there? Okay, one more question.
Ashley Fernandez asks, would the panel explain the science behind the positions they take on the humanity of the unborn child? What empirical evidence specifically are they relying on to say that either life begins at conception or as a fetus, even up to the point of birth, is not an individual entity, but a part of the woman, like an organ would be? There are other religions that see this in a different way, with life beginning at the first breath.
So I will take a stab at this, and although my background is science, this is not my specialty, so I'm not going to comment on the science of it, except to say that there are, we heard from many individuals in the medical community about this question of not only viability, but what that means. And also, as you pointed out, we also heard from many individuals from various faiths who have a very different view on when life begins. For example, in the Jewish faith, life begins at first breath. And so this brings me back to, again, the laws that have been put in place by a legislature who has a very extreme view on this issue, or at least has voted in a very extreme way on this issue, does not at all respect the various views and opinions on this issue of life, and also on the science of viability as well. And that was very clear in the debate for the 6-week abortion ban.
I will just quickly say that the question reminds me of the position of Justice John Paul Stevens, who took the view that, in fact, decisions about when life begins embodied in anti-abortion laws are essentially adopting a religious position, which is violative of the Establishment Clause of the Constitution. So that is something that has been advanced. It's never commanded a majority of the court.
Mr. Gonidakis? No. Okay. I am going to pass this back to Deb Hackathorn for some concluding remarks.
Well, I hope you found today's forum interesting, informative, engaging, and enjoyed this lively discussion. Thank you to the Columbus Dispatch for supporting today's forum. Thank you to our online virtual seat patrons and the Emergency Response Fund of the Columbus Foundation for presenting our live stream in partnership with the Columbus Dispatch. Special appreciation to today's speakers, Mike Gonidakis, Dan Kobil, Allison Russo, and our host, Jessie Balmert. Please join me in thanking them. Please make plans to join us next Wednesday for a forum spotlighting Code Launch, a new tech accelerator coming to Columbus. If you haven't heard of Code Launch yet, think Shark Tank for software developers. Thank you all for joining us. We couldn't do it without you. We look forward to seeing you next Wednesday as the Columbus Metropolitan Club presents another community conversation. Thank you. Thank you.